Afternoon, everyone. Thank you for joining us. I'm Senator Patricia Canzanieri Fitzpatrick. I represent the 9th Senate District in Nassau County. And today we're here to discuss the recent decision from our state's highest court, the Court of Appeals, in People v. Weinstein, and the legislation that our conference is introducing to address this miscarriage of justice. Time and again, our conference has warned about the predictable repercussions that would result from policies out of Albany that prioritize partisan politics and criminals over everyday New Yorkers. Unfortunately, it wasn't enough for the legislative supermajorities to advance those priorities through the laws themselves, but last year they insisted on pushing this through our court system. And now a conviction that represented justice and accountability to so many women, in particular, against individuals in positions of power who abuse this position and commit sexual violence, was overturned in People versus Weinstein. It is important to remember how we got to this untenable point in an effort to hold individuals accountable for wrongdoing. My very first day here in Albany as a state senator, we voted to increase the number of members of the Judiciary Committee. And that was the beginning of the Democrats in the Senate majority to have a path toward choosing the Chief Justice of our Court of Appeals. We had a very qualified candidate for the position of Chief Judge, and purely for partisan politics, the advocates for survivors of sexual assault raised the alarm about the Senate's preferred pick, and now our current Chief Judge. Many of us, unfortunately, and too many women know just how difficult it can be to come forward to go through the legal process to ensure that perpetrators of sexual violence are held accountable. In People versus Regan, we had a victim who did everything the legal system requires. She immediately reported the assault. She endured a 4-hour rape kit examination. She had to tell and retell and relive the horrific crime over and over and over again. But at least momentarily, justice prevailed when a 12-member jury of her peers found that defendant guilty. However, our now Chief Judge Wilson penned the decision to overturn that conviction on questionable technical grounds. And even Judge Singas stated in her dissent in People versus Weinstein, quote, "fundamental misunderstandings of sexual violence," close quote. In fact, Judge Singas dissented in People versus Regan and People versus Weinstein, and she noted that overturning the conviction, the court is continuing a disturbing trend of overturning juries' guilty verdicts in cases involving sexual violence. We should all be disturbed by the outcomes that have resulted from the majority's out-of-touch priorities, but we should not be surprised, because we saw this coming. My only surprise is that this demonstration of completely misguided priorities and interpretations of the law have reared its head so quickly and in such a high-profile case, almost exactly 1 year after Chief Judge Ronan Wilson's confirmation. Like many other issues coming out of the progressive agenda, where some policies may sound great in hypotheticals and in theory, but when these policies run into reality, we have disastrous results. Too many policies coming out of Albany are simply too far detached from the reality of how the world works, especially with crime. The cat is out of the bag, and we know that there are several examples that demonstrate how the majority of this court view holding individuals accountable for alleged sexual violence. The question that remains is, will the legislature step up and take action to make our laws clear so that we can hold individuals accountable and so that we can stop prioritizing criminals over law-abiding New Yorkers? Now I'm going to turn it over to my colleague from Nassau County, Senator Steve Rhodes.
Thank you, Senator Canzoneri Fitzpatrick. Make no mistake, what you are seeing with the Harvey Weinstein case is a symptom of a much larger problem. And Senator Canzoneri Fitzpatrick gave you a little bit of the history of that. We have had a majority in the New York State Senate that has made the people of the state of New York over the course of the last 6 years, has made them less safe, less prosperous, and less free. But they weren't satisfied having complete control over what happens in the state legislature, having control over what happens in the governor's mansion. They needed to go further. And by going further, they needed to infiltrate the courts. And that's exactly what happened with the appointment of Rowan Wilson as Chief Justice of the Court of Appeals. The simple fact is, Hector LaSalle, prior nominee who this conference supported, who the governor supported, wasn't liberal enough, wasn't progressive enough, wasn't pro-criminal enough. And so when we talked about stacking the Judiciary Committee, which was one of the first things that happened, as Senator Canzoneri Fitzpatrick alluded to, by adding 3 additional Democratic members, but only 1 Republican member, when it's supposed to be proportionate representation, is because the one thing the Democrats can do is count. And they counted votes, and they knew they didn't have enough to overturn Hector LaSalle's nomination. So they added a member of the Judiciary Committee. That's the reason, for the process that played out over the next 2 months, that's the reason that Hector LaSalle's nomination was defeated. And now we have Chief Judge Rowan Wilson. The problem, though, is the warnings that we received, that Chief Judge was a progressive, that Chief Judge was soft on crime. His pattern with respect to sexual crimes of his decision-making would rear its ugly head. And that's what you're seeing today. It was more important to the Democratic majorities to have a favorable decision out of the Court of Appeals on their redistricting case, which is what this was all about, that will deal with the sexual violence, the sexual abuse, being soft on crime, the other issues that we're seeing coming out of the Court of Appeals now. So we have a much larger problem with politics here in Albany dominating the conversation, even in the courts, which are supposed to be neutral arbiters standing up for justice for all. We see that not happening. But we have a bigger problem with the process. Rowan Wilson has used the process of vouching in for years, bringing justices from the appellate division to come up when there's a vacancy in certain circumstances on the Court of Appeals so that the court can make a decision with the full bench. But instead of going through a rotation system, instead of using the traditional means of selection, the judges that came up were judges that had made decisions both in the redistricting case as well as in the Harvey Weinstein case that had reached decisions on similar issues previously and had decided the way the chief judge wanted them to be decided. And so the selection process itself is now called into question as to whether the litigants who are coming into the Court of Appeals, depending upon the issue, are going to get a fair hearing and get a fair decision out of the Court of Appeals. We can't stand for the Court of Appeals to be politicized. And so the legislation that we're introducing today, and I'll speak about my bill, which is S-9601, actually limits the ability for justices to be able to recuse themselves. If a justice of the Court of Appeals is going to recuse themselves under existing law, they do not have to provide an explanation in open court. In certain circumstances, they don't have to provide an explanation at all if it's of a personal matter. This legislation will change that. Litigants in the Court of Appeals deserve to know, and the people of the state of New York deserve to know, that the individuals who the legislature, their elected representatives, have confirmed are going to be sitting and going to be hearing the cases that they're assigned to. If they're not, they're entitled to an explanation why. And so under this legislation, anytime a Court of Appeals justice recuses themselves, The reasons for that recusal have to be made in public on the record. Secondly, we are now creating a rotating system among the appellate division judges that if the court is going to vouch in another justice to fill its bench, it must be done from the appellate division, and it must be done on a rotating basis based upon seniority from appellate division justices. This way, we don't have a situation where the chief judge of the Court of Appeals is able to cherry pick who they want based upon whether or not they're going to be making decisions that ultimately game the system and cast into doubt the impartiality of the Court of Appeals process. And now we are going to speak about some of the more technical revisions that are part of Senator Palumbo's bill that are dealing directly with the Harvey Weinstein case and directly with some of the issues that are raised in Molyneux. So I will turn it over to Senator Palumbo.
Thank you, Senator Rhodes. And without being too repetitive, and the good thing about my colleagues, Senator Canzonieri, Fitzpatrick, and Senator Rhodes, is that we're not only elected officials, we're lawyers, so we're never at a loss for words. But we ultimately have addressed really the meat of these issues. But I just want to comment a little bit further on that. When you think about the foreseeability of all of this has been completely telegraphed. In the Harkenrider case, the first redistricting case, Judge Wilson dissented and said that and the comments were essentially that even though it may appear to violate the Constitution, congressional districts can clearly be drafted in partisan fashion, and it would comport and comply with the New York State Constitution. So he said that, and what did our Senate Democrat friends say in the majority? He's for me. Prior to his confirmation, I specifically asked him, as a ranking member on the Judiciary Committee at his confirmation hearing, what can you tell us to ensure that women will be protected in light of the decision in Reagan where you fabricated and created a new legal standard? The delay was 4 years. The statute of limitations on rape doesn't exist. There is no statute of limitations on rape. So if you're raped 20 years ago, you can still be prosecuted today. More importantly, in that analysis, he said there was no prejudice to the defendant. Yet, he felt the need to legislate from the bench in a rogue and radical fashion and dismiss a first-degree rape conviction where someone was unanimously convicted by a jury of their peers, and it's gone. You can't appeal after that. The case is over. The rapist goes free, and the victims have no rights. So this is, once again, just a prime example of putting political gains and political interests over victims' rights, period. They were warned, and I'll read you a comment from Sonia Osorio, who is the New York City chapter of the National Organization for Women, prior to the confirmation of Rowan Wilson. She said, I have to point out just the fundamental unfairness and misogyny that's built into this reasoning. That's the way to serve rape victims is to throw out their convictions as a way to spank prosecutors. That is unacceptable. It fully disqualifies him to lead this court. She further stated that this elevation of Rowan Wilson to the Court of Appeal is going to go down in history as one of the worst decisions that has come out of this administration and this legislature. Period. That essentially says it all. She was absolutely right that this is such a dangerous and terrible decision. And then we move into the Weinstein case, who was also a huge Democrat mega donor, has a lot of connections to New York, although that might not necessarily even be relevant because this is, again, law that has existed for over 100 years. And when Caitlin Halligan and Shirley Troutman said that for undisclosed reasons, Caitlin Halligan said she knew one of the litigants, despite telling us to the contrary, that her relationship with the appellate bar will not affect her ability to sit on cases. She recused herself. Judge Troutman just recited the statute. We brought in Christine Clark and Betsy Barros. Again, the telegraphing of where they were going was quite obvious. Betsy Barros rendered a decision, ironically, dissented a decision drafted by Hector LaSalle and the majority, confirming the gun conviction of a defendant who said it was his girlfriend's gun. on 2 prior occasions. One, he wasn't charged. He was an NBA basketball player. He said, oh, it's my girlfriend's gun. He was found with a gun in a pillowcase on an airplane. They didn't charge him. The second time, he said, it was my girlfriend's gun, the loaded .45 in the console. He actually pled guilty to a misdemeanor criminal possession of a weapon, then gets arrested in New York and says, it's my girlfriend's gun. They put the prior 2 cases in under that case Molyneux, and Betsy Barrow said she would have thrown that case out had she been able to get her way in her dissent in the Telfair case. So clearly now you have a chief judge who's manipulating the court, who's manufacturing votes to suit his progressive and activist. This is as activist a court as you can find. Why? That gets me to the legislation. Because now the legislature needs to respond with law to try and bind the courts to fix it. He's legislating from the bench. It's outrageous, it's dangerous, and this bill will simply codify what's called the Molyneux rule. And my bill's a little different than some other bills that have been proposed, because I looked at some other bills, and I know that some Senator Janoris picked up Amy Paulin's bill. Specifically in New York state law, you need to have the judge continue to render a balanced decision once you can determine whether the evidence is relevant and admissible. So we always used to say in the DA's office, it's the mimic rule. It's motive, intent, absence of mistake, identity, or a common scheme, like signature type aspects of a crime. If you can establish that, that's why it's coming in, not to show that this person has a propensity to commit crime, then the judge balances a probative value versus prejudicial effect standard to still ensure the defendant's rights are abided by. So that's essentially all that this bill does, is it codifies Molyneux. Now, the federal statute and many other states allow prior bad acts or sexual assaults into a current sexual assault into evidence. However, it needs to be limited to an extent that the judge still must have, if you can prove relevance, the ability to exclude it based upon really fairness to the defendant. For example, someone's committed 15 robberies in their lifetime. They're now charged with robbery. Clearly, they committed this robbery. That's not how it works in the state of New York. We need to prove the elements of each and every new crime with new, relevant, and legally admissible evidence. You can't just say this is a bad person, that they now should be convicted. So that's really the nuance of it. I can get further into it with any questions, but this package of bills is going to, most importantly, fix this terrible loophole that was created by, I'll suggest, a rogue judge. We knew it was coming, but they were more concerned about the right decision on redistricting than they were about the safety of women in New York. And I tell you this, folks, there's more to come. We can't see where it's going now, but if this judge is allowed to continue in this fashion, to vouch in people that'll agree with him, instead of just allow and mandate that the judges who sit on the Court of Appeals, who are confirmed and get the big bucks to sit there, they're the ones that should be rendering these decisions. Or, like we've done for the previous several decades and decades in New York State, when a judge recuses themselves, as long as there's a quorum, you render a decision with who's left. It's quite simple. So I thank you for your time. I thank you for coming with that. I'll open it up to any questions.
I'd like to ask about, well, the controversy rating makes a few of you mentioned that ultimately that case is tossed out and that's the overturned because the argument is that the law delayed when the investment studying the benefits draft violated the defendant's right to shoot off this trial. Is there anything in this legislation or this speech that would address that specifically? Is there anything in this way?
There's not. There is not. I mean, you can't necessarily, I think, it's a very good question. I would think that to an extent we could discuss pretrial delay and reasonable excuse, but this is one of those standards in the law where reasonable excuse is it's objective in a way, but it's like the reasonable man situation where would someone placed in a similar circumstance, could their conduct be seen as reasonable? And that's with the pretrial delay. But the biggest factor, and there's, I can't remember the statute or the case law because I brought this up in the confirmation hearing. There is a list of, under the case law, of factors to be considered. For example, prejudice to the defendant, reasonableness of the delay and those similar factors. But really, one of the heaviest, the seriousness of the crime is another one. And actually, I remember specifically asking Judge Wilson, I said, so if we're talking about 42 months was the delay in the Reagan case on a rape case, if it's something like a grand larceny or an election law type case, then clearly a similar delay, you'd be even more likely to dismiss a case like that. And he said, well, that would make sense because obviously rape is much more serious than an election law violation or a grand larceny. I said, okay, well then 60 months was the delay on the trial that's going on in Manhattan right now at the time former President Trump was just charged. I said, so out of hand, I guess that case should be dismissed as well. And then he did a little bit of a dance and gave kind of a non-answer. So, there are some factors that are already considered, but really the biggest two are prejudice to the defendant, seriousness of the crime. In the Reagan case, they were both at maximum volume as far as no prejudice to the defendant, specifically held in the decision, and as serious as a crime as you can get. You're welcome.
Okay, the wait, you start the legislation wait down 5 years, top, so you're going to, what? And it's, you're going to pass this is more than.
Yes, something needs to be done. I personally would. I would think that there would need to be a chapter amendment. That bill, and I actually brought it along, thinking that may be the subject of some of our discussion. And that bill, I get the intent. I'd be shocked if it passes both houses, quite frankly, that we've already seen the Democrats have a splashy press conference with now holding signs, "We protect women." Where have they been? Where have they been? They knew this was coming when Wilson was sitting in that chair for confirmation and they had blinders on. All they were concerned about was getting him on the bench to render the decision on the new redistricting case so they could start from scratch. Again, politics over victims' rights. But this specifically has, and I'll read you this paragraph, in the Gianaris bill. In a criminal proceeding in which a defendant is accused of a sexual offense, the court may admit evidence that the defendant committed any other sexual offense. Such offense may be considered on any matter to which it is relevant, including to prove that the defendant acted in conformity therewith or had a propensity to engage in similar wrongful acts. Out of hand, I believe that's unconstitutional because of that language. So I would hope that this passes, either one of them, and that this is actually a little more expansive than my bill, and that we would have to amend it to clean it up to make sure that it complies with the Constitution. I'd be open to either one of them. My bill, quite frankly, we just have the judiciary members on it, is that I did an initial draft and ran it by our conference's members of the judiciary. We submitted it, and we're going to submit it to the rest of the conference, and I can assure you that they'll be interested as well to be co-sponsors of it, and I will do it Senate-wide.
Jason?
Are they saying that at the confirmation process, go ahead and put the goods on differently, Harvey Weinstein, so that they can have.
Without question. Without question. Look at the Telfair case. People versus Telfair. As I said, the majority decision written by Justice LaSalle. And more importantly, it should have been actually 3-2 because 5 would still constitute a quorum. So the 3 dissenters in the Weinstein case would have actually had the majority opinion, and it was already affirmed on the appellate level. So that would not have been enough to overturn it. So that would still be, his conviction would still be upheld, number one. But in Telfair, similar to the Weinstein case, the evidence presented was classic Molyneux evidence. What was Weinstein's defense? It was consensual. He said, I was getting sexual favors for professional favors. Period. We're adults. We're consenting adults. This was all consent. That absence of mistake aspect of Molyneux was why they were submitted, saying that these prior assault victims and rape victims, they were clearly lured in the same fashion as the victim in the current case, in the New York case. Therefore, their evidence is relevant, and it shows that he's using the same story. It's not to be believed because this is a pattern of behavior. So I would think, without question, that number one, we wouldn't have had 2 favorable judges, very liberal judges, who already had basically rendered decisions that they would overturn a similar type case. And more importantly, even if we had vouched in other judges, regardless of what their decision were to be, Justice LaSalle would have been the 4th majority decision.
And it's unfortunate because you have a scenario here where instead of letting the evidence and the facts lead the court in a particular direction, you now clearly have a court and a chief judge that is deciding in advance how he wants the case to come out. And then we'll find the judges who will get him the majority to make that happen.
Yeah, exactly. And that's why I say manipulating and manufacturing votes, looking around the state and seeing prior decisions and saying, here's someone on my team, here's someone on my team. For an intended result.
Well,
I think Judge Clark had some indications previously. My understanding is she was also appointed by Judge Wilson to some other an administrative body of some kind since then. But I just believe that there may have been conversations had, because the Betsy Barros has, in black and white, her decision was clear that that's the direction she would go in. And I just believe from what we've seen before, and I'm sorry I'm not giving Judge Wilson the benefit of the doubt that he just so happened to randomly pick Judge Clark. We've seen too much. Like, the first time this happens, like in Reagan, shame on you. Second time, now shame on me. You're not going to fool me twice.
Any more questions on Alec? So said we can support Gene Arias' bill. I was curious, if this is courtesy of the state to the Democrats, why would they let a council like that? Then every night, that said that there's
because it's unconstitutional. I know it's not going to pass. I'm sure.
yeah, might.
All right, I think because they know it's probably unconstitutional. And why? Because it's politics. It's an election year. They were getting bludgeoned in the media. I'm sure you saw several articles about how outrageous this Weinstein decision is. And look, if it wasn't Harvey Weinstein, it probably would have stayed under the radar. But because he's a Hollywood producer, it's an international case, people are aware of the Harvey Weinstein case and what an animal and pig he was. He is a horrible human being who should die in jail. Quite frankly, I hate to be that aggressive about it, but he has done this for years. And now it comes to the forefront, and you actually, non-legal, Brian's here with the Law Journal, but non-legal newspapers and periodicals discussing the nuance of the confirmation process and Rowan Wilson and how he's a progressive judge, and they manipulated and did constitutional gymnastics to get rid of LaSalle and get him on the bench. So I think this is 100%, it's politics now, because they were put on the spot, and look what they did. While this was being after this was placed in bill drafting, 4 days later, we saw at the New York City chapter of NOW with We Protecting Women press conference announcing that they were taking up Assemblywoman Paulin's bill in the Senate. So they had to do something politically. And sadly, I think this has very little, if not nothing, to do with the right thing and protecting women's rights in New York. This has to do with politics, just like the appointment of Rowan Wilson did.
And so, they got their decision. They got their maps.
Yeah, go ahead.
Just to add to what Senator Palumbo said, they've already got their decision, which was the sole purpose for putting Judge Wilson on the Court of Appeals. They got their redistricting decision. So now they're seeing the damage, and maybe they're taking a step back. But as Senator Palumbo eloquently stated, the Gianaris bill, we believe, probably wouldn't hold muster. So let's say that it does pass. Judge Wilson is going to say that this should be overturned. It's unconstitutional. Therefore, I'm going to ignore it. So we do need to fix it the right way.
Just sort of show a little bit what down the line said so.
Depends.
Oh, sure.
Yeah.
It's really not.
Sure, it's the end of paragraph 1. Indicating specifically, that's mine. This one is, including lines 8 through 10, really 7 through 10. Such evidence may be considered in any matter to which it is relevant, including to prove the defendant acted in conformity therewith, which is similar to Molyneux, or had a propensity to engage in similar wrongful acts. A propensity to do so. This person is a sex offender, therefore he's definitely guilty of this one. That's not allowed in New York. You can't do that. You can't say you need to prove the current case. That's the way it works. I was a prosecutor for years. I handled these types of cases. It's just something, and look, this is actually our conference protecting defendant rights by clarifying this and putting out a statute that can actually hold water.
Senator, one of the ballot is asking, should the legislature not pass this, legislature as a whole not pass this? Should Democrats expect to hear about this? you realize, just
Well, of course, but that's not really the point. Well, I think we'd rather see it pass and become law, because now we have cases. And this is, again, remember how they keep talking about confusion with bail reform? How judges, and it's just a list. The judges have a list of eligible offenses at the bench. Not a hard thing. They're educated people. And they're saying they really struggle with which cases, which types of charges are bail eligible. You think they're going to be able to just skate right through this? This is really complex stuff. And so now every single time a prosecutor tries to put in a sex assault case, a prior sex assault, they're going to look at the Weinstein decision and say it's inadmissible. I'm sorry, sit down. Again, closing the mouths of victims and survivors who already have to do tremendous work to come forward. They're heroes. The bravery it takes to talk about that is outrageous. And as I said, I've handled these cases, and it is not easy for these victims. And now you're going to silence them even more? Where's the Me Too movement? With the stroke of a pen, it's been destroyed, thanks to Rowan Wilson.
taking a step, how looking at a 30,000, the investment 30,000 would. So with this, we have a late case going on, and this case going on right now. Do you get a sense that the legislature may be on a enforced what appeal to stay the next year or two? And what else on that on there? That's asking you to look at this.
Yeah, I know. I don't want to speculate as to that too much, but I understand where you're going with that. But quite frankly, and as was mentioned by my colleagues and Senator Canzoneri Fitzpatrick, they weren't satisfied with just controlling the legislature. They needed to now manipulate the one place that is supposed to be, a sanctuary of fairness, the courts. This is where the judges are supposed to be, it's supposed to be off limits, that you don't need to put politicians on the bench. You want to put intellects, very smart people who are going to be fair and balanced and simply apply the law to the facts, not change the law to their political whims.
He were coupled on time.
So you saw the JNR's bill with fraud for gays and unmarked small term job this praise.
Possibly, yes, in my opinion.
Well, we could like say
Well, something's better than nothing, right? This needs to be dealt with. This is a very serious issue, number one. Number two, we do chapter amendments all the time. Ultimately, when bills get to the governor, we can tweak the language and clean it up. That's done very often in this body, as I'm sure you're aware.
One on topic. Now, the senators, stupidity and this blame is like, the mayor, I'm going to pass on Weinstein and stay get the students from to the and that's we're now here talking to their areas. What is there on great want to see done but to address that big thing?
We have some friends on that task force, who just happen to be.
Yes, so I am a member of the Senate Task Force to combat anti-Semitism. I'm happy to see that they are having a discussion. We weren't invited, we weren't told. Anytime that we've had press conferences, and there's been many, we have not seen any of the colleagues from the Democrat side present. They have not spoken out publicly. They have not condemned what's going on. And I do think that it's high time that they recognize that this is an issue. And I'm hopeful that they will look at the legislation that this conference proposed, because what we need to do is take serious steps to impact institutions with their funding if they do not respond appropriately to what's going on their campus.
That and detail everybody think is the ones who want reaction should be taken, and that lawmakers should apply.
Are you talking about like the proposed legislation that we put out, where we said that if administrators are not, there's been several bills that I could speak to, but the one that I think is most relevant is the fact that if administrators or faculty are engaged in anti-Semitic activity, that there needs to be action taken by the administrators of the institution, and that if they are not properly dealing with it, stopping the conduct, protecting all students, that their funding should be withheld. There's a number of bills that are going on, but that's the one that I think is most relevant to your question.
Yeah, Senator Weber, for example, has a bill that would pull TAP funding from, you want me to hop on the microphone? Yeah, Senator Weber, for example, has a bill that would pull TAP funding, for example, from students that are engaging in that type of hateful activity. Understand, the pro-Hamas activity that's been taking place on campus, and we're not talking about demonstrations against the war. We're talking about slogans like, "We are Hamas," "From the river to the sea." Right? Look at a map of the Middle East. That calls for the destruction and the annihilation of the Jewish state and the Jewish people. If that type of activity, actual threats are occurring that are supporting a terrorist organization, which Hamas is, under 8 U.S.C. 1189. It is a terrorist organization. Those are activities that cannot take place on any campus, public or private. And if the administration refuses to do something about it, then the action that we can take is to pull whatever funding that they receive for it.
Any other question?
Just your reaction, though. You were here last week, studying your third coast those bills, and not one Democrat came up and stood with you. And today, they have students from Cornell, not Columbia, Cornell.
Right. Which, incidentally, if I'm not mistaken, is the campus where students were barricaded inside of a library because they had a pro-Hamas group that was outside ready to attack them, if I'm not mistaken.
Was Cooper.
Was Cooper Union? All right, so I correct that. Apologies to Cornell. What was the incident at Cornell?
Well, those follow it.
Ah, there you go. There you go. Look, you know, there's words, and not to disparage Senator Stavisky's press conference today, but we're done with words. We need action. And we have proposed probably no less than a dozen bills at this point between the task force and individual members that would address directly the issues that she was talking about today. All she has to do is take up one of them. Take up 12 of them. The ideas are there, but they haven't even been seen in committee, much less been brought to the floor. If you want to do something about it, the opportunity to do something about it is there, and I challenge Senator Stavisky to do something about it.